എല്ലാവർക്കും നമസ്കാരം. ഇന്ന് ഞാൻ ഈ വീഡിയോയിൽ തയ്യാറാക്കുന്നത് നിയമവിദ്യാർത്ഥികൾക്കുള്ള ഒരു പഠന സഹായിയാണ്. കോൺസ്റ്റിറ്റ്യൂഷണൽ ലോ. കോൺസ്റ്റിറ്റ്യൂഷണൽ ലോ 1. സെക്കൻഡ് ചാപ്റ്റർ, സിറ്റിസൺഷിപ്പ്, സ്റ്റേറ്റ് ആൻഡ് ജസ്റ്റിഷ്യബിലിറ്റി ഓഫ് റൈറ്റ്സ്. ഫസ്റ്റ് പാർട്ട്, സിറ്റിസൺഷിപ്പ്. Who is a citizen? Citizen is a person who enjoys civil and political rights fully. He enjoys full membership of the political community. Citizenship is a legal status determined by the specific rights and duties. Every citizen of India is called as Indian national. There are certain fundamental rights which are available only to the citizens of India. Example, Article 15, 16, 19, 29, 30, etc. Aliens do not enjoy all these rights, but Article 14 and 21, etc. are available to aliens too. Therefore, citizenship is a relationship of an individual with the state. Next, acquisition of citizenship. According to Article 5 to 8 of the Constitution of India, a person shall become citizen of India in the following ways. They are: first one, citizenship by domicile or birth. Article 5. Every person who has his domicile in the territory of India and who was born in the territory of India, or either of whose parents was born in Indian territory, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. Domicile means the home or the place where a person resides with the intention to remain there permanently and without any present intention to remove him therefrom. It does not include a special or temporary residence. Abdas Samad versus State of West Bengal. All India Record 1973, Supreme Court 505. Supreme Court explained domicile as the home or the place where a person resides with the intention to remain there permanently and without any present intention to remove him therefrom. It does not include a special or temporary residence. Another case is in Union of India versus Dattanath Prasad. All India Record 2000, Supreme Court 525. It has been held that domicile and residence had to be understood in the context in which they were used. The Parliament had enacted the Indian Citizenship Act 1955 under Article 11 of the Constitution of India. The Act provides for the acquisition and termination of citizenship. Next is citizenship by migration. According to Article 6, a person who has migrated to India from Pakistan shall be deemed to be a citizen of India at the commencement of the Constitution of India if he or his parents or any of his grandparents were born in India. Next, citizenship of migrants of Pakistan. According to Article 7, a person shall cease to be a citizenship if he has migrated to Pakistan after March 1, 1947. Next, citizenship of Indians abroad. According to Article 8, a person of Indian origin residing outside India can obtain citizenship of India by fulfilling the following conditions. That conditions are: such person or either of whose parents or grandparents was born in India as defined in the Government of India Act 1935. Second condition is that registration as a citizen of India by the diplomatic or consular representative of the country where he is for the time being residing. Next, no dual citizenship. According to Article 9, a person who has voluntarily acquired the citizenship of a foreign state shall not be deemed to be a citizen of India. No citizen of India can claim a dual or plural citizenship. Next, citizenship under the Citizenship Act 1955. Citizenship Act 1955 was enacted under Article 11 of the Constitution of India. The Act provides 5 ways of acquisition of citizenship. They are by birth, by descent, by registration, naturalization, by incorporation of territory. By birth, by descent, by registration, naturalization, and by incorporation of territory. Next, termination of citizenship. Citizenship may be lost if the following 3 ways occur. They are renunciation of citizenship by declaration. Renunciation of citizenship by declaration. Next, voluntary acquisition of citizenship of another country. Next, compulsory deprivation of citizenship. What are that case? Those cases which has terminated citizenship. That cases are renunciation of citizenship by declaration, voluntary acquisition of citizenship of another country, compulsory deprivation of citizenship. Next, whether company or corporation be regarded as a citizen. Whether company or corporation be regarded as a citizen. With reference to Article 19, only natural person can be regarded as citizen. In R.C. Cooper versus Union of India case, All India Record 1970, Supreme Court 564, popularly known as Banks Nationalization case. It has been held that where a legislation affects the company for which an individual is a shareholder, it infringes his rights and hence he can file a writ petition on behalf of the company. Thus, an individual's right is not lost for the reason that he is the shareholder of a company. Next points to remember. Citizenship is enjoyed by all the citizens. It provides a legal status by specific rights and duties. Aliens do not enjoy all these rights except Article 14 and 21. A person residing outside India can obtain citizenship. A person cannot claim dual citizenship. Citizenship may be terminated by renunciation. Only natural person can be regarded as citizen. Yes, we can see the questions from this chapter. Please explain the questions. Please answer the following questions. Define citizenship. Explain the principles relating to citizenship. Define citizenship and explain the principles relating to citizenship. Next, discuss the constitutional provisions relating to acquisition and termination of citizenship. Yes, we can see one problem and solution. Problem is that X, a Christian missionary who had temporarily came to India, had challenged the order of the central government expelling them from India on his failure to acquire Indian citizenship. X claimed the Indian citizenship and contended that he became citizens of India by virtue of Article 5 subsection C, 5C of the Constitution of India, as they were staying in India for more than 5 years immediately before the commencement of the Constitution of India. The issue of this problem is that whether the order of the central government is valid? Yes. Whether X had an intention to stay permanently in India? No. Whether stay of X makes him eligible to acquire citizenship? No. Whether the contention of X is tenable? No. Whether the petition of X is maintainable? No. Rule pertaining to this problem is that according to Article 5, every person who has his domicile in the territory of India, according to Article 5, every person who has his domicile in the territory of India and who was born in the territory of India, or either of whose parents was born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be a citizen of India. Next, we can see the application of this problem. Domicile means the home or the place where a person resides with the intention to remain there permanently and without any present intention to remove him therefrom. It does not include a special or temporary residence. For the acquisition of a domicile of choice, it must be shown that the person concerned had a certain state of mind and animus munendi. If he claims that he acquired a new domicile at a particular time, he must prove that he had formed the intention of making his permanent home in the country of residence and of continuing to reside there permanently. Residence alone, unaccompanied by this state of mind, is insufficient. The burden to prove that the petitioners had an intention to stay permanently in India lies on them. The available materials on the record leave no room for doubt that the petitioners did not have such intention. At best, it can be said that they were uncertain about their permanent home. Every person must have a personal law, and accordingly, everyone must have a domicile. He receives at birth a domicile of origin which remains his domicile wherever he goes unless and until he acquires a new domicile. The new domicile acquired subsequently is generally called a domicile of choice. The domicile of origin is received by operation of law at birth, and for acquisition of a domicile of choice, one of the necessary conditions in the intention to remain there permanently. The domicile of origin is retained and cannot be divested until the acquisition of the domicile of choice. By merely leaving this country, even permanently, one will not, in the eye of law, lose his domicile until he acquires a new one. This proposition that the domicile of origin is retained until the acquisition of a domicile of choice is well established and does not admit of any exception. Mr. Louis D. Redet and others versus Union of India and others, All India Record 1991, Supreme Court 1886, the petitioners who were foreign nationals challenged the order of the central government expelling them from India on their failure to acquire Indian citizenship. The petitioners came to India before independence and were staying continuously on the basis of foreign passport and residential permits. They were engaged in Christian missionary work. They contended that they became citizens of India by virtue of Article 5C of the Constitution of India, as they were staying in India for more than 5 years immediately before the commencement of the Constitution of India. It has been held that they failed to establish that they had an intention to reside in India permanently. The petitioners did not have their domicile in India. For the acquisition of a domicile of choice, it must be shown that the person concerned had a certain state of mind, the animus munendi. If he claims that he had acquired a new domicile a particular time, he must prove that he had formed the intention of making his permanent home in the country of residence. Residence alone, unaccompanied by this state of mind is insufficient. Domicile of origin is lost only on acquisition of domicile of choice and not on mere continuous stay on other country. Next case is Union of India versus Nath Prasad. All India Record 2000, Supreme Court 525. It has been held that domicile and residence had to be understood in the context in which they were used. The Parliament had enacted the Indian Citizenship Act 1955 under Article 11 of the Constitution of India. The Act provides for the acquisition and termination of citizenship. Central Bank of India versus Ram Narayan 1955. One is Supreme Court record 697. It has been held that by merely leaving his country, even permanently, one will not, in the eye of law, lose his domicile until he acquires a new one. This proposition that the domicile of origin is retained until the acquisition of a domicile of choice is well established and does not admit of any exception. Another case is Hannes Muller of Nuremberg versus Superintendent. Hans Muller of Nuremberg versus Superintendent. Presidency Jail, Calcutta and others 1955, Supreme Court record 1284. It has been held that the power of the government of India to expel foreigners is absolute and unlimited, and there is no provisions in the Constitution of India lettering this discretion. We can conclude this problem like this, that in the instant problem, the order of the central government is valid because X had no intention to stay permanently in India. The temporary stay of X does not make him eligible to acquire citizenship. The contention of X is untenable. Hence, the petition of X is not maintainable. നമുക്ക് കോൺസ്റ്റിറ്റ്യൂഷണൽ ലോ മലയാളത്തിൽ നോക്കാം. ഇന്ത്യൻ ഭരണഘടനയിൽ പൗരത്വം സംബന്ധിച്ച വ്യവസ്ഥകൾ ഭരണഘടനയുടെ ഭാഗം 2 ആർട്ടിക്കിൾ 5(2)(11) പറയുന്നത്. പൗരത്വം എന്നത് ഒരു വ്യക്തി രാഷ്ട്രവുമായുള്ള നിയമബന്ധമാണ്. അതിലൂടെ അവൻ രാജ്യത്തിൻ്റെ അവകാശങ്ങളും ഉത്തരവാദിത്തങ്ങളും പ്രാപിക്കുന്നു. ജനനകാലത്തെ പൗരത്വം, അതായത് ബൈ ഡൊമിസൈൽ, ആർട്ടിക്കിൾ 5 പറയുന്നത് ജനനകാലത്തെ പൗരത്വം. ഭരണഘടന പ്രാബല്യത്തിൽ വന്ന 1950 ജനുവരി 26 സമയത്ത് ഇന്ത്യയിൽ സ്ഥിരതാമസം ഉണ്ടായിരിക്കുകയും ഇന്ത്യയിൽ ജനിച്ചവരായിരിക്കുകയോ അല്ലെങ്കിൽ ഇന്ത്യയിൽ ജനിച്ച മാതാപിതാക്കൾ ഉണ്ടായിരിക്കുകയോ അല്ലെങ്കിൽ 5 വർഷം ഇന്ത്യയിൽ താമസിച്ചിരിക്കുന്നവരോ ആണെങ്കിൽ അവർക്ക് പൗരത്വം ലഭിക്കും. കുടിയേറ്റം മുഖേന, അതായത് ബൈ മൈഗ്രേഷൻ, ആർട്ടിക്കിൾ 6 and 7. പാകിസ്ഥാനിൽ നിന്നും ഇന്ത്യയിലേക്ക് വന്നവർക്ക് ചില നിബന്ധനകൾ പാലിച്ചാൽ പൗരത്വം ലഭിക്കും. ഇന്ത്യയിൽ നിന്നും പാകിസ്ഥാനിലേക്ക് പോയവർക്ക് പൗരത്വം നഷ്ടപ്പെടും. പക്ഷേ മടങ്ങി വരുന്നവർക്ക് രജിസ്ട്രേഷൻ മുഖേന പൗരത്വം ലഭിക്കാം. നെക്സ്റ്റ്, രജിസ്ട്രേഷൻ അല്ലെങ്കിൽ നാച്ചുറലൈസേഷൻ മുഖേന, ബൈ രജിസ്ട്രേഷൻ ഓർ നാച്ചുറലൈസേഷൻ, അത് ആർട്ടിക്കിൾ 8 സിറ്റിസൺഷിപ്പ് ആക്ട് 1955 പറയുന്നതാണ്. ഇന്ത്യൻ വംശജനായ വിദേശത്ത് താമസിക്കുന്നവർക്കും ഇന്ത്യയിലേക്ക് വന്ന വിദേശികൾക്കും നിയമപരമായ നടപടികൾ പാലിച്ച് പൗരത്വം ലഭിക്കാം. നെക്സ്റ്റ്, ഡുവൽ സിറ്റിസൺഷിപ്പ്, ഇരട്ട പൗരത്വം. ഇന്ത്യയിൽ ഇരട്ട പൗരത്വം അനുവദനീയമല്ല. ഒരു വ്യക്തി മറ്റേതെങ്കിലും രാജ്യത്തിൻ്റെ പൗരത്വം സ്വീകരിച്ചാൽ ഇന്ത്യൻ പൗരത്വം സ്വയമേ അവസാനിക്കും. നെക്സ്റ്റ്, പൗരത്വം നഷ്ടപ്പെടുന്ന മാർഗങ്ങൾ, ടെർമിനേഷൻ ഓഫ് സിറ്റിസൺഷിപ്പ്. സിറ്റിസൺഷിപ്പ് ആക്ട് 1955 പ്രകാരം സിറ്റിസൺഷിപ്പ് ആക്ട് 1955 പ്രകാരം റിനൂൺസിയേഷൻ, അതായത് സ്വമേധയാ ഉപേക്ഷിക്കൽ, ടെർമിനേഷൻ നിയമപരമായി അവസാനിക്കൽ, ഡിപ്രൈവേഷൻ സർക്കാർ മുഖേന റദ്ദാക്കൽ, അതുമൂലമെല്ലാം പൗരത്വം അവസാനിക്കാം. കമ്പനി അല്ലെങ്കിൽ കോർപ്പറേഷൻ പൗരത്വത്തിൽ വരുന്നതാണോ, പൗരനാണോ? അല്ല. പൗരത്വം വ്യക്തികൾക്കാണ് ബാധകമായിട്ടുള്ളത്. കമ്പനികൾ, സ്ഥാപനങ്ങൾ തുടങ്ങിയവയ്ക്ക് നിയമപരമായ വ്യക്തിത്വമുണ്ട്. നൈയാമിക വ്യക്തിയാണ്, പക്ഷേ പൗരത്വം ഇല്ല. അവയ്ക്ക് രാഷ്ട്രീയ അവകാശങ്ങൾ, അതായത് വോട്ട് ചെയ്യൽ, തെരഞ്ഞെടുപ്പ് മുതലായവയിൽ പങ്കെടുക്കാനായിട്ട് സാധിക്കില്ല. നെക്സ്റ്റ്, ഭരണഘടനാനുസൃതമായ നിയമങ്ങൾ ആർട്ടിക്കിൾ 11 പറയുന്നതാണ്. പൗരത്വവുമായി ബന്ധപ്പെട്ട കൂടുതൽ നിയമങ്ങൾ ചെയ്യുന്നതിനുള്ള അധികാരം പാർലമെൻറ്റിനാണ്. അതനുസരിച്ച് സിറ്റിസൺഷിപ്പ് ആക്ട് 1955 പാസ്സാക്കി. സിറ്റിസൺഷിപ്പ് ആക്ട് 1955 പ്രകാരമാണ് പൗരത്വ അവകാശം കൂടുതലും ഡീല് ചെയ്യുന്നത്. നമുക്കതിനെ ചുരുക്കത്തിൽ നോക്കാം. ആർട്ടിക്കിൾ 5 ഡൊമിസൈൽ അടിസ്ഥാനത്തിലുള്ള പൗരത്വം. ആർട്ടിക്കിൾ 6 പാകിസ്ഥാനിൽ നിന്നും കുടിയേറ്റം ചെയ്തവർക്കുള്ളത്. ആർട്ടിക്കിൾ 7 പാകിസ്ഥാനിലേക്ക് പോയവർ. ആർട്ടിക്കിൾ 8 വിദേശത്തുള്ള ഇന്ത്യൻ വംശജർ. ആർട്ടിക്കിൾ 9 ഇരട്ട പൗരത്വ നിരോധനം. ആർട്ടിക്കിൾ 10 തുടർച്ചയായ പൗരത്വം. ആർട്ടിക്കിൾ 11 പാർലമെൻറ്റിൻ്റെ അധികാരം. ഓക്കെ, അപ്പോൾ എല്ലാവരും ക്ലാസ്സുകൾ തൃപ്തിയായി എന്ന് വിശ്വസിക്കുന്നു. താങ്ക് യു ഫോർ ഓൾ. Please follow and subscribe me. Thank you once again.